Hello and welcome to True Crime Daily's The Sidebar, taking you inside the courtrooms of high-profile and notorious cases from across the country. I'm your host, Joshua Ritter. I'm a criminal defense lawyer based here in Los Angeles and previously an LA County prosecutor for nearly a decade. We're recording this on Monday, April 11th, 2022. And today we are joined by Julie Grant, a former prosecutor, trial expert, and award-winning legal journalist, and you may know her as a host on Court TV. Julie, thank you so much for joining us.
My pleasure, Josh. Great to be with you. This is exciting for me.
Oh, good. Before we jump in, and I know you're going to have some really good insights on these cases because you cover them every single day and you know exactly what's going on.
Very kind.
You have such a very interesting story about how or what led you to become a lawyer. Could you share that with us?
Sure, I'll be glad to. So maybe it's being a Gemini, I don't know, but I always had an interest in both journalism and law. And as a young kid, I never was quite sure how to be able to do both. And so I can remember like years ago sitting in the office of one of my college professors and saying, you know, he was one of my broadcast journalism professors. And I was saying, I really do want to go to law school at some point, but don't quite know when. And I remember him saying, oh, you could be on Court TV someday. And I thought, wow, wouldn't that be so cool? And, here we are. But what I wound up doing, after that conversation with him was I went and I worked for my hometown television station, really great NBC affiliate in Steubenville, Ohio, that is a small station that really runs itself like a big station. Everybody comes out of there really well trained. And I really had to prove myself to get in there. It wasn't easy to land a job there. It was really tough. It was really competitive at the time. And so, started out as like a temporary freelance and temporary, then finally got an anchor job. And then after a few years anchoring their morning show and reporting on their noon show where I would cover the court cases and be on the kind of crimes, courts, cops beat unofficially, but I wound up doing a lot of that. I really had my interest peaked in the law and in trial work and especially public service. I kept thinking what those lawyers do day in and day out, the ones that serve as prosecutors and public defenders. And I thought, I really think I want to go to law school. So I wound up leaving that job to then go back to school full time because I really wanted to be a better journalist, wanted to be as smart as I could be. And I thought, if nothing else, law school is going to make me smarter. I never really thought I would practice, but then kind of got bit by the trial bug, so to speak, because they recruited me for the trial team, as you can imagine, because of the TV background.
Sure.
So wound up doing that. And it was kind of a shock to my parents because I had this job that I really, really wanted in broadcast journalism. And then suddenly I'm like, I think I want to go to law school. And I remember my mother saying like, that's wonderful, honey, but are you sure you want to leave this? And, and remember my dad, who's not very opinionated at all when it comes to, like choices and things when it comes to my career. And I remember saying, Dad, what do you think? And he said, I think we need a Tom Hagen in the family, honey. I think law school would be a good idea.
I like that.
For you. Nice little Godfather reference.
Oh, yeah.
Your listeners, Josh, who know the movie. Yeah, so became the Tom Hagen family.
I love that. That takes guts, though. I'll tell you. I mean, I know how competitive those networks can be sometimes, and to be able to walk away from that, and it obviously worked out, but I'm sure there were some times where you thought, am I doing the right thing?
Oh, absolutely. I mean, it's so hard when you try to work so hard to get one of those jobs. And even at a small market station, TV news can be really, really competitive. And at the time, there were a lot of really talented people that were also working there. And you really have to prove yourself and show that you're smart and can work well and do great storytelling and be flexible. And so, it was kind of, a really big switch to then go back to being a student. But I kind of felt like I don't want to get too old and too tired to go to law school. Right. It's really, not something for the weary. And that, my gosh, you're the one with the impressive career, Josh Ritter. Wow. We're also impressed with you at Court TV and always love when you come on our shows as a guest. We fight over
thank
you.
Thank you. Yeah. Good to hear. All right. Well, let's jump right in. The first case we're going to talk about is one of those stories where it's, of course, the truth is stranger than fiction, and I mean all the puns intended here, because we're talking about Nancy Crampton Brophy, and she is the romance novelist who's on trial for the murder of her husband. Dan Brophy was shot in June of 2018 at the Oregon Culinary Institute in Portland, where he was a chef and professor. He was found bleeding on the floor by his students, and this is interesting, with no sign of a robbery or forced entry. Nancy Brophy was arrested in connection with the killing in September of 2018. There are reports that the couple struggled financially. Dan had a life insurance policy worth nearly $1.5 million. And in 2011, Nancy authored a blog post entitled "How to Murder Your Husband," of course, right? Now, interestingly, the judge has not permitted that to be used as evidence in the trial. There is evidence that she researched and purchased ghost guns. These are the types of guns that are unregistered, supposedly untraceable. And reportedly, she swapped, and this was also very diabolical, she swapped the slide and barrel of the murder weapon with an identical mechanism that she had purchased on eBay, thus having a gun, as long as she disposed of that barrel, that wouldn't match any ballistics, but she could still provide the police with the gun that they knew that she had purchased. One little interesting side note in our research was that the Brophies had a wedding ceremony in 1997 and filed joint taxes, but weren't legally married until shortly before Daniel Brophy's murder. Okay, so let's jump right in. I want to get just kind of your thoughts on the case, because this case is so interesting to me. It's one of those where people will call it's a whodunit, but it's really closer to a who else could have done it, right? That's kind of the way the prosecution's putting it together. What are your thoughts been so far?
Exactly, Josh. If not Nancy Brophy, then who? Right. That is really what the state of Oregon is saying about all this. And I know there is no burden whatsoever on the defense. I know they don't have to put on a shred of evidence. I know Nancy Brophy is cloaked in the presumption of innocence, and you know all of this so well, especially because of your practice doing criminal defense work. But I really think in order to successfully defend this at trial, there has to be a then who shown to this jury. Somebody wanted this beloved man dead. And something I think you'll think kind of is fascinating, Josh, our crews have been there since this trial began. And so our incredible reporters, crime and justice reporter Matt Johnson, legal correspondent Julia Janae, their field team partners, videographers, field producers, they're all digging in. And what they're finding in the Portland area is that Dan Brophy was the one who was beloved. Dan Brophy was the one who was well known. Dan Brophy was a name in Portland. Nancy Brophy, not so much. The first day when Matt Johnson was out there, he started covering this trial from the beginning, and then Julia Janae picked it up. She's there now still. But he went there and he went looking in the used bookstores to try to see if her books were anywhere to be found. Couldn't find a thing. Wow. And so I have a little bit of a theory. If you want, I'd love to share it with listeners. Please, yeah. I think if the state wants to be successful in this prosecution, I think they have to pinpoint a motive really hard. And I know they pinpoint money to a degree. They were saying that because of all these multiple life insurance policies that Nancy Brophy had out on her husband's life, that she stood to gain $1.5 million. I think it's more than money. I think the motive, if I were the state, should be fame. Because in order to get that fame, I think she would be wanting to use that money. So I'm not saying the money wasn't connected. If I'm the state, I would say it was. But it seemed to me like this woman had really invested a lot of time and energy on developing this career that really never took off. And for some reason, there was this sick fixation with marriage and her spouse and with committing a homicide. I mean, of all the things you can write about, Josh, I don't know. Right. She had to choose this. For her chosen topic for all these varying books and things she wrote. So I think that it seems to me, based on what our teams are telling us who are on the ground there, that Daniel Brophy was the beloved one. Daniel Brophy is who had so many friends, so many students who admired him, and people are just devastated because it's such a foodie town in Portland. Americans who haven't been to Portland may not realize, like, that's where the food trucks were born. It's a place where the culinary world is thriving and always has been. And so he was somebody, I think that's kind of something that may get lost in the trial. It's sensational, the romance novelist murder trial, but it also has to do with this man who was really, really loved, and this woman who seems to me, if I'm the state, was really seeking a lot of attention.
Yeah, that's very interesting. I had not heard that angle before. I like that take on it, because I'll tell you too, and motive is something that you talk about. We always talk about how the state does not have to prove motive, and we're going to talk about that in another case that we consider today too, and that's true. But I always think, and especially in a case like this, that it's a mistake to just rely upon that. And if you're standing in front of a jury at closing argument and you're saying, no, I don't have to prove motive to you, I think you're losing them. That you need to give them something to hang their hat on. And it's so interesting that you point that out in this case here, because they keep on coming back to, well, there was $1.5 million life insurance policy. I'm not saying that's not a lot of money. That's a lot of money. But is it murder money? I mean, if we're talking $20 million, maybe you could understand people start researching ghost guns and sneaking up behind your husband or something. But 1.5, it doesn't seem like that compelling an interest. But maybe with the angle you're talking about, maybe that is it. Who knows?
That's an excellent point. And I think you're right. Both points you made, that one and then the former, with if you can have a strong motive, offer it anytime you can do that. I know, I'm sure if you harken back upon your time as a prosecutor, and I'm just thinking, one case just kind of jumped out at me as you were talking, Josh, thinking about how I remember struggling doing a case and not knowing, and none of us knew what the motive was. This was so heinous. And I remember talking to the detectives about it. And I had a companion case. So it was not to digress too far, but it was a brutal stabbing case, and there was the dismemberment of a corpse, and there were two people who were involved in abusing the corpse after the fact, the person who murdered the victim, and then another friend. And so I was enlisted to prosecute the friend, and a colleague of mine in my office was prosecuting the murderer. And I remember we met so much, we talked this out, and like there was no reason that this poor victim should have been stabbed. It was like nobody knew what it was. And I remember being so troubled by that as one of the advocates as part of this case, thinking like, oh gosh, is the jury going to be troubled by this? They weren't. They convicted him so fast, as they should have. It was horrible. But it's if you can offer it, do it, to your point, right? Because you don't want those jurors back there in the room wasting time guessing, right?
Yeah. No, you understand legally why it's not required, but people are people, and people naturally want to know the why. And if you don't provide them with a why, I think you're going to lose the jurors. And and who knows if that ends up being a problem in this case. We're going to find out soon enough, I guess. Okay, so turning now to another strange one, Michael Barisone. This is the former Olympian in horse dressage, which I never had heard of before, but it's this kind of elaborate horse riding that involves kind of like dance or something, I guess you would say, right? He shot Lauren Kanarek twice in the chest and fired at her fiance, Robert Goodwin. And this was at Barisone's horse farm in Long Valley, New Jersey. Barisone, who was also Kanarek's former trainer, she was into this horse dressage competing, said that she was behind on rent. And then there was also evidence that Kanarek testified that how Barisone was bullying in behavior, and that prior to the shooting, he had made comments to her about sleep with one eye open. His defense has not contested that Barisone pulled the trigger, but they have asserted that he was suffering from temporary insanity after a months-long dispute, and that his mental state felt threatened. At one point, it looked too like they were putting together an alternative theory of self-defense, but the judge is not going to instruct on self-defense, so they're going to have to go in with this temporary insanity. And to that end, Barisone has appeared very frail and restless in court, which I'd like to hear your thoughts on, which is a very different change from his normal demeanor as a 6'3" former Olympian. So, first of all, what are your thoughts on the judge throwing out the self-defense argument, meaning he's not going to give that instruction to the jurors?
Right. I actually think it worked out well for the defense, Josh, even though they didn't intend for it to happen that way. And this is why. I don't think for the defense it works at all to present both a self-defense case and a not guilty by reason of insanity case. Yeah. It's like they just don't go together. It's because, and you know this so well, if you're going to say you acted in self-defense to defend yourself or defend someone else, you've got to know what you're doing and understand the facts around you. Whereas insanity, it's exactly the opposite. You don't know, you don't understand, you can't appreciate your actions and the why and the what. So it's just, I was confused from the outset that defense counsel put forward both of these. And especially because I'm thinking, well, you've got to pick one, because you don't want that jury struggling with what we're talking about right now on your podcast, thinking, well, these don't exactly seem to go together legally. And then also thinking, well, which one was it? No, tell them what it was, commit to it, marry it, stick to it, embrace it throughout the whole trial. That's your legal theory. And for me, I think the insanity defense is so much stronger to the point you just made. I mean, my gosh, Michael Barisone looks terrible.
Yeah.
And I'm not saying that in a disparaging way. I'm saying that in the most empathetic, understanding way possible, that I hope he gets the mental health treatment that he needs. Because here you have this Olympic champion who became a coach and was respected and beloved, driven to the point that he was in such a state of despair that he couldn't function anymore. And here you see him in the courtroom looking like he can barely function. And so I think the way this case has played out, I think the judge made the right call. As you know, Josh, the defense has that burden of production. They never get the burden of proof. The burden of proof always stays with the state, but the burden of production to show that he acted in self-defense has to be met in order to get the instruction. And the court felt that that burden of production wasn't quite met, but the burden of production was met on the insanity defense. So the jury has heard that and is going to be deliberating that. So I think it kind of worked well for counsel. I think this is just so much stronger because that self-defense argument was messy too with the facts of this. I mean, this was something terrible happened with this brawl between the three of them and the dog. We know Michael Barisone was bitten by this dog, and it's hard to know who attacked whom first. It's really very unclear. So I think this whole narrative the defense is putting on, that these two alleged victims were basically mean squatters who wouldn't leave and thought it was more fun to torture him, I think that bodes more well for them anyways.
Yeah, no, I completely agree with you. I thought it was a mistake. Listen, sometimes defense attorneys will have alternate arguments, right? You know, if my guy didn't do it, but if he did do it, you know, here's an excuse why. And you can understand that sometimes a little bit of confusion works for the defense. You know, maybe they just throw enough at the wall, something sticks with a couple of the jurors. But you make such a good point here that those are diametrically opposed defenses. I mean, you're right. In one sense, you're saying he was so out of his mind, he couldn't even appreciate what he was doing and the consequences of it. Oh, and if you don't buy that, well, then he absolutely appreciated everything he was doing because he was acting in self-defense because he was so afraid for his own life. And you're right. You can't do both. And I agree with you that there seems to be more evidence. You know, there's these weeks of buildup of where you could maybe see a couple of jurors buying the idea that maybe this guy just a screw went completely loose at that last minute.
Mm-hmm. Yeah. Oh, yeah. You can see how it happened. I mean, just the buildup and I think when, you know, as lawyers, like, we get how stressful trials can be. And even though we, you know, have practiced, you're currently practicing in the criminal world, excuse me. And that's where I practice. The civil world can be so crazy stressful. Yeah. You know, and the litigation, you usually hear that word attached to the civil or the litigation, you know, when you're getting papered to death is how I like to think of it. You don't know what's coming in the mail today. I mean, it can be awful. And so I think he kind of felt trapped, like he's suing them in civil court. He's trying to get them off his property, and the police can't do anything about it because it's not criminal. And he's calling police. He's in such a state of despair. When you really lay it out, it's like, and then you think, like, why didn't they leave? Why didn't they leave?
Right.
Why didn't they want to get away from this? It just doesn't smell right. I think their narratives, to me, they stink a little bit. When I was watching their testimony, I thought, this doesn't really pass the smell test. For me, trying to watch objectively, you know this, Josh, we call balls and strikes at Court TV. We don't have a horse in the race. No pun intended. My gosh, I did not mean to.
Well done.
With this case. I say that with every case. But here, it's all the more fitting.
Well, that should be that we might even have a verdict in that case by the time this podcast airs. They've finished closing arguments, right? They're just waiting on the jurors. Wow. Yeah,
you're correct. As we were getting set up for this podcast, they finished. The judge instructed them, and I'm just getting a note in right now that they're going to go back on the record soon before the judge.
Oh wow,
the jury for the day. So we'll see.
Breaking news. Yeah,
when this goes to air.
Another one that we could have a verdict any day now is Dr. William Husel. And this is the trial of the doctor charged with 14 counts of murder for his treatment of patients while serving in the ICU at Mount Carmel Hospital in Grove City, Ohio. He's accused of essentially overprescribing fentanyl and other medications which hasten the deaths of the patients. And it's important, though, to keep in mind that these were patients nearing death as it was. I mean, they were close to, within hours of, if not days of passing themselves. The original case focused on 25 deaths, but in January, the prosecution dismissed 11 charges to focus on patients who had received 1,000 micrograms of fentanyl, which is a very high dose, we're learning, and other medications. Last week, and this was kind of a breaking thing last week, an affidavit of disqualification was filed by the defense to remove Judge Michael Holbrook from presiding over the case. The affidavit was under seal. We don't know what it said, but we do know that it was denied and closing arguments proceeded forward. I want to talk first, let's talk about that bombshell filing and help people to understand just how rare a thing it is about this affidavit of disqualification. Can you fill us in a little bit on what was happening here?
I'll do my best, Josh. I wish I knew more to share with your listeners and viewers. What was tough was because this was put under seal, so we couldn't see it. And so we were relying heavily on what the local newspaper, the Columbus Dispatch, was reporting. So anything we had shared I think they got the most scoop on this case just through some source reporting. We had, of course, cited them and credited them for that digging. But it is very rare, as you know, to have attorneys filing a motion while the trial is going on, to have the trial judge disqualified. So what was essentially reported here was that this motion and affidavit in support of the motion to disqualify the trial judge was filed with the Ohio Supreme Court. So going way above the trial judge's head here. And the Columbus Dispatch was reporting through source reporting that it was the defense team that had filed this through, I guess, the basis that was reported. I'm kind of paraphrasing here, but what they said was that when it came time for the defense to choose to present a defense, and we know they have no burden, there's no expectation, whether they present a shred of evidence or not cannot be commented on, can't be held against them. Same as, with a defendant's right to testify. Every defendant enjoys that right. It cannot be held against them. If in this case, Dr. Husel chose not to, and the defense wasn't as robust as I think many people expected it to be.
Right.
There was one expert witness that was presented, and I believe the judge made some kind of comment to the effect that this was a tactical decision to not present more. Something about a tactical decision was the quote that was put out in the local paper there. And apparently there was issue taken with that, but it was hard for us because we weren't able to read this and know exactly what it said, know exactly what was argued and how they felt that might have in some way prejudiced their case. But as you noted, everything moved forward. This was denied. We saw the closing arguments playing out. And I guess the one thing I was kind of left thinking when it comes to whether, or not a defense could have been presented, should have been, even though there is no expectation under the law. Josh, I kept thinking that Dr. William Husel could help himself by giving testimony in this one. Do you think the same thing?
Oh, yeah. Absolutely. It's always such a rare strategy by a defense attorney to want to put their own client on. Usually that's never the case, right?
Right.
But with this type of a client where he's got no criminal history, from what I understand, he was very adored by the community. Correct. And he can go up there and explain, I was just trying to help these people. And yeah, maybe I'm giving them more drugs than other doctors would have, but we can agree to disagree that there's different ways that you can give this kind of end of life care. I think it would have added some humanity to the whole thing for him, and it was a surprising move. As is this move to challenge the judge. I don't get it. I mean, it happens every once in a while. People will challenge a judge before anything begins because they feel that judge is somehow not the right fit for their case or something. But to do this right before closing arguments, the judge's job is done. Right? Any effect he could have had on the case is almost over. It's now just arguments and instruction. So I was wondering, is this kind of a shot across the bow of the judge, or were they preserving something for appeal? I don't know. And we're dealing with Jose Baez here, who is no rookie to these types of big cases. I mean, he handled Casey Anthony's case, famously to acquittal, and he represented Aaron Hernandez. A weird couple of choices. I agree with you on the challenging and then not putting his client on. I don't know. What are your thoughts on the case itself? Do you think that the prosecution's met their burden?
That's tough. And the reason for me, for a couple of reasons, it's a tough case for them to meet their burden, I think, in general. And also, we've had so many trials going at once. If I'm being totally honest, I want to be, on your show with your listeners. So there have been times when we haven't been able to broadcast Husel on our air. It's gone on our live stream, or we haven't been able to stream it. So there are parts of it I was not able to see. But I will say this. I found it kind of troubling from the outset for a number of reasons. And don't get me wrong, it is awfully tragic that these people lost their lives. Don't get me wrong, my heart breaks for anyone who lost their loved one in a situation where they feel they weren't given the proper medical attention or mistreated. My heart goes out to all of them. Here, to the point you made when you were introducing this part of the podcast, Josh, is that these were patients that he saw in the intensive care unit. That's where they were. So context is really key in this one for me. Sure. This is, as you pointed out, some of them, they're on ventilators. Some of them, I mean, these are last-ditch efforts to make them comfortable at a time that is critical. It arguably is the end of their lives. And again, I say arguably because the state's taken a different position on this one, but this one was played out in civil court already. I mean, like this, there were so many lawsuits, so much money paid out. I don't know. I haven't been privy to all the evidence in this case. I mean, I would love to see everything that the state reviewed when they made the decision to want to go after him and prosecute him, because I'm just not sure that it belongs in criminal court. I found a lot of the testimony very hard to follow. It's hard for anyone to understand. I'll be the first one to admit. I mean, many times I'm listening and you're hearing about the micrograms of fentanyl, and unless you're somebody like who's spent your career in the DEA or, in the hospital and you're administering it, that's something, it's really hard to understand the quantities and the lethality. And it's this doctor did so much good in his life, and he's an award-winning doctor, now suddenly finds himself on trial. And when there were so many other people involved in the administration of medications and these things, the whole thing, I don't think is very clear cut. I think the state really took a chance on this one. And I guess I wouldn't be surprised if it goes either way, because again, I didn't see the entirety of the testimony. I wish I had been able to, but I was disappointed that he didn't testify, because I think that someone so smart like that could get up there and really explain the situation and go patient by patient and say, look, I remember this woman. I remember the condition she was in. What you didn't hear was this about her. And I think just to hear him kind of be a human and be like on the same level as anybody on the jury, I would want to be spoken to like I'm 5 years old if I was on the jury, like really dumb it down for me, help me to understand what you did and why. And I kind of feel like this, Josh, when you're on the defense side, all you need is one to hang a jury. And if they get a hung jury, I can't see the state going back after him again. I mean, the resources to spend, they ought to just let it go. In my view, if it doesn't go the way they want it to.
Yeah.
So that's kind of my take.
No, those are all super solid points. I agree with everything you're saying. Yes. Again, anytime there's people dying and perhaps there are reasons why they didn't need to die the way they did or at the time that they did, your heart obviously goes out to all of those victims' families. But I agree with you. I think this was a mistake to bring this prosecution. I wonder about the precedent that it's setting, with the message that it's sending to the medical community. I mean, if you're a doctor, if there was a law that said you cannot give 1,000 micrograms of fentanyl, okay, I could understand that. He broke the law. But from what I was hearing, there's kind of a lot of diverse thought on what is too much and what is, why. Well, I don't do that as a doctor. We heard a lot of experts say, but some of them could understand it, And then just to go back to a point that we were talking about earlier, where's the motive here? Why? What if he was doing this? Why? Why be doing this to these people? And again, I think the prosecution is going to have a real tough time if that's all they're standing there telling the jurors in closing arguments is we don't have to prove motive. They're going to have to give these jurors something to hang their hat on if they want them to convict this doctor. Do you agree?
Absolutely. I'm so glad you said that. I think that is so key. And I think throughout the weeks and weeks of this, I'm glad you brought it up because I absolutely forgot about this. They never pinpointed a motive. Yeah. The state did not pinpoint a motive. And they really could have come up with, so many different things that they could have said. And I think if you're on the jury, you're going to be like, okay, look, you're hearing testimony about this guy being well respected, a great teacher, an award winner, practicing for years and years. And like, why would he want to kill people when he takes that oath to help people and has helped so many people? And even some of the testimony cut both ways. I can remember some of the family members getting up there testifying for the state and talking about things he said to their loved ones that were very compassionate and kind and helpful. So I think that's really lacking here. That's a really great point for this jury to send this doctor to prison, essentially. I'm sure, they can, even though they're not charged with punishing him, that would be up to the court to dole out a punishment if he's convicted. You would think they would want to know why he did what the state is accusing him of doing. Something to answer that why question, and they just haven't done it. And so I sit here as you do, finding myself just kind of confused as to why this was brought as a prosecution. Well, then turning to the last case we're going to talk about, but it will be on court TV, I'm sure, from morning till night, every single day for the next few weeks, is Johnny Depp and Amber Heard. They are set to square off in Fairfax, Virginia for a massive defamation suit. Depp alleges that Heard defamed him in an opinion piece she wrote about domestic violence that was published in the Washington Post. And even though Depp was not named in the op-ed, he claims that it caused him to lose out on a potential relaunch of the Pirates of the Caribbean franchise with Disney, which we can only imagine what kind of money we would be talking about there. So 6 years after the divorce, there's a $50 million libel trial is opening on Monday, the 11th, today. And the judge has allowed a video camera in the courtroom, reportedly for the first time in Fairfax County. And the judge overseeing the trial has imposed a series of access rules to try to maintain decorum in the courthouse. Good luck with that. Most significantly, neither Depp nor Heard are permitted to pose for photos or sign autographs while in the courthouse or on the courthouse grounds. Amongst those who are potentials to testify are actor James Franco, billionaire Elon Musk, and perhaps even Johnny Depp himself. Is this just a circus, or is there something more serious here? What are your thoughts? Oh my gosh. Where do I begin with this one? So this will be a doozy. This will be a doozy to watch. So we've got these dueling defamation claims is essentially what is going on here. As you know, Josh, we've got the claim from Johnny Depp saying that Amber Heard defamed him when she wrote that article, that op-ed in the Washington Post, didn't name him, but under the law, that doesn't matter if he can prove the defamation case has been set out through his lawsuit. But he says he was defamed by that. And then we've got the counterclaim from her saying there were statements made by Depp and through his counsel that are defamatory against her. And the counterclaim is for $100 million. And so we've got a really, really ugly set of allegations between a couple that used to be in love and used to be married, and a couple that has lived much of their lives in the public spotlight in Hollywood with lots of paparazzi around and lots of people taking notice of all their behaviors. And underneath it all, I do think there is something serious, and I'm going to be really curious to see just how it plays out through the trial. Is there are these allegations coming from both sides of domestic violence. And, that's something, of course, that's very serious, something that I think is so tough to talk about. It's a hard subject to breach. It's a really hard subject to understand. I know those of us who've worked and served in the criminal justice system understand how frightening it really is. And I'm going to be curious to hear what comes out to that end underneath all this, because we know that in the civil world, truth is a defense to defamation. And so we've got these horrific abuse allegations coming, from both sides, and each side is going to be refuting them. And so I think we're going to hear some very, very ugly, nasty stories. And I also don't think what we're going to hear about is for lack of a better way of saying it, like the typical domestic violence dynamic where typically, and you know this, Josh, from serving as a prosecutor, you have people who use violence against their intimate partners, and they use it as the way to control them. They don't have an anger management problem. They use it as a way to exert power and control over their victim. And their victim is in love with them and loves them as a person, but wants the violence to stop. And it's not easy for them to get out of this dynamic because it happens slowly, it happens incrementally. And I think what's really tough is, with these two, you're not hearing about it being one-sided, at least from what came out in the UK case, which was such a mess, where he sued the son because they called him a wife beater. There was evidence presented, on both sides of this, that they both had been violent with one another on more than one occasion. So I'll be curious to see what comes into evidence with this one, and see if at the end, if it's clear that one or the other was the person using violence, or if it's a situation of just two people who can't manage their anger, not the typical domestic violence dynamic, but two people that are just explosive. And a lot of this we know was fueled by drugs and alcohol and rage. And it seems a lot like these are people who need better conflict resolution, and perhaps needed, I don't know if either of them were undergoing mental health counseling, but from the evidence we saw, so we kind of got a peek at this case, as you know, through that last one.
Right.
It was nasty, just really nasty. And I said it before in court today, I'll say it again. It's amazing to me that nobody died. Wow. I mean, hearing about the instances between these two, it was so ugly, so explosive, so dangerous from what has been come into court as evidence, albeit not a U.S. court, but a court overseas, the United Kingdom, where that first trial took place. They are both very fortunate that this didn't end very badly. So I think they can both thank goodness they're alive and well today. And I don't know what they're both thinking they're going to gain with this, Josh. I really don't. Yeah. I don't think the juice is worth the squeeze for either one of them.
Yeah, that's such a good point. One thing you talked about that I wanted to touch on is this idea that in a defamation case, a defense is truth, right? So if he's saying you defamed me and she can prove that he in fact was abusive to her, then that's a defense to that, which made me think, if you're his lawyers, this isn't like a criminal case where you can get kind of caught off guard by some evidence. They've had discovery, right? They've had depositions. Yes. They've had interrogatories. They've been going at this. So they know everything that's coming out in this trial. And you got to be thinking they had Johnny Depp's people must have gone through everything with a fine-tooth comb to make sure there's no evidence of that if they're going to bring a lawsuit like this, because that's absolutely what Heard's team is going to do, is try to make him look like a total abusive person and use every bit of evidence that they can. And I agree with you. Is the juice worth the squeeze here? Because talk about reputational harm. Everybody's going to end up with reputational harm at the end of this thing, with the sound of it, right? The stories that you said from the previous case. How does this help repair his career? I have no idea.
That's exactly my thought. And I wonder about the advising, that's going on for both of them. Yeah. Because you have to think, when this is it's all becoming part of the public record. The media is all over this one because it's been such a spectacle, and it's very, very sad. And I don't know. I mean, look, like we've talked about before, Josh. You know this. You come on Free TV regularly as one of our favorite legal analysts. We call balls and strikes. We don't have a horse in the race. We don't have a dog in the fight. We are not Team Johnny. We are not Team Amber. We are just reporting the facts and the law and analyzing the testimony and the evidence as it comes in. And so for all of this to get to the point where they're each proving these defamation claims, where this, Josh, to be an attorney, when it's a public figure, you've got to prove that it was done with malice, meaning that they knew the statements about one another were false, but still they did it anyways. You're right. All this ugly stuff has to come out and has to be public and part of the court record and part of the evidence, and then be reported on. And then even if somebody does, win this case, even if there's a judgment in favor of one or the other, are they really the winner after everyone's heard it all and all of this ugliness? I mean, in civil court, the burden is far less than criminal court. And so it's much easier to make out a case in civil court than it is in criminal court. Even if they can make out their cases, I don't know that I would want it out there. I mean, sometimes just being silent and quiet and private is the best way to kind of quash whatever might be swirling around out there. But, it's their right to choose otherwise. And we're just glad our cameras can be there for it all, because in the United Kingdom, we weren't able to see it all. So it was tough, right? We just got like little pieces here and there we were able to examine. So here, start to finish, we will be there for it all, Josh. Our cameras will catch all of this. And they're both expected to.
There's not a clear winner or loser with them, but the real winner here is Court TV and your viewers, because everybody's going to be glued to their sets watching this thing for the next couple of weeks.
Oh, thanks. Our viewers are very anxious. They're definitely into this one.
We're looking forward to it. Julie, thank you so much for coming on this week. Where can people find out more about you?
Thanks for having me, Josh. Oh, I appreciate it. So you can catch me any weekday, noon till 3. I should say 12 p.m. to 3 p.m. Eastern time is when I host the midday show on Court TV. And you can always go to my website. It is juliegrantesq.com. And there are links if any of your listeners want to talk more about any of this on social. Glad to do that as well.
Oh, fantastic. And I'm your host, Josh Ritter. You can find me on Instagram and Twitter at Joshua Ritter ESQ. And you can find our Sidebar episodes wherever you get your podcasts. And we want to hear from you. If you've got questions or comments you'd like us to address, tweet us your question with the hashtag TCD Sidebar. And thank you for joining us at the True Crime Daily Sidebar.